Hello everyone, welcome to MastersTeach, and today we'll discuss about the interpretations of statutes. So, what is statute? It is a written law made by parliament or legislature. So, everyone in the country must follow it. Usually, it applies to the future, not to the past. So, it overrides unwritten common law. So, what is statute? So, basically, whatever the bill passed, discussed, and approved in the parliament, that is a law made by the parliament and the or the legislature. So, everyone in the country must follow it. Usually, these statutes or these laws made for the future, not for the past. So, it also overrides unwritten common law. So, when you're writing the exams, try to write these definitions. One is Salman. What he says, a law that shows what legislatures wants written in a clear and official way. Then what Maxwell says, a law made by the highest law-making body in a country. As per the Black's Law Dictionary, a written law passed by government's law-making body. So this is about the meaning, definitions of statute. I hope you understand the same. So let us see what are the types of statutes. When the examiner asks what are the types of statutes, you have to write codifying, consolidating, declaratory, remedial, penal, mandatory versus directory. So these are the types of statutes. So what is codifying? That means, so existing law in a country that is written in a book in a regular format, okay, that is called as codifying. For example, Transfer of Property Act. What is consolidating statutes? It is a merging several laws into single law. For example, CPC 1908. Okay, merging means different laws together put in one law, that is called consolidating. What is declarating? So it clarifies what the law already means to clear up confusion. So one law is already there. So what it does, it gives the clarification, this is the right law, you have to follow. So in order to clear the confusion, that type of statute called declaratory statute. Then remedial or beneficial statute. So which gives the people more rights, interprets broadly. For example, when the case is there, corporation and laborers, so it benefits the people's right, it benefits to the laborers, it benefits to the affected person. That is a remedial or beneficial statute. Then it comes to the penal. So it sets out punishment, interprets strictly. So for example, IPC. So it is about the penal, means it is about the punishment. That is the type of statute. Then mandatory versus directory. That means the law must be followed. What is directory? It is a guidelines only, whether you follow or not. So the types of statutes are codifying, consolidating, declaratory, remedial or beneficial, penal, mandatory versus directory. So how you have to remember? CC, DRE, PT, MD. That means codifying, consolidating, declaratory, remedial, beneficial, penal, mandatory versus directory. So that you have to remember. Let us go to the next slide. So meaning and definitions of interpretation. This is also one of the important meaning and definitions of interpretation. Okay, so there are four things are there. One is literary meaning, purposive interpretation, legislative intent, and judicial decisions. So why it is need literal mean? That means start with the plain words, everyday meaning of the words. Then legislative intent. So we have to find out what the lawmakers were trying to achieve through this in, through this statutes. Then purpose interpretive. So if the meaning unclear, look at the purpose of the law. Then judicial decisions. So applying the interpretation to reach final judgment. So we discussed about the statutes. So different types of statutes. Then we are discussing about the interpretation means explain why you have to interpret. One is in order to get literal meaning, then legislative intent, then purposive interpretation, and judicial decisions. So like this is the thing, the key principle why it is needed. Words can be vague or have gaps, courts must fill them. Goals. So in order to find out what is the lawmakers really meant, literal meaning, that means first step, use the plain ordinary meaning of words. Purposive, if the words are unclear, interpret them to match the law's purpose. So this is the thing about the interpretation. Let us go to the next slide. So General Class Act 1897. So in order to avoid repeating the same definition in every law, instead of giving common words, one standard meaning used across all central acts. For example, the key sections S6, what happened when the law is repeated. Section 13, words for one gender or number cover all. S4, powers can be used again and again. S16, so rules about making appointments. So important rule in general clause, definitions in the general clause act apply to all the laws unless specifically law says something different. So in order to avoid the repetitive definitions in everyday law, they have give some conclusions in the name of General Clause Act. So this is the thing. Then grammatical literal rule. So meaning and feature, use the normal everyday meaning of words even if the results seem unfair. Advantage, clear and predictable respects the parliamentary road. Disadvantages can lead to strange or unfair outcome. So landmark cases is that Whiteley versus Chappell 1868, following the words literally gave an odd result. Then Sussex PH case, so 1844, courts must use the plain meaning of words. So this is the grammatical literal rule. So always mention Sussex peerage case when writing about the literal rule. Then we'll discuss about the golden rule. Golden rules means it start with the plain meaning of words, but if that leads to silly or unfair result, change the meaning just enough to fix the problem. There are golden rule two types. One is narrow. When a word has two meanings, pick up one of the that makes more sense. Second one, the type 2 golden rule is that wide. Change the word's meaning slightly in order to avoid obscure outcome. So here, literal rule means plain meaning may cause obscurity, whereas golden rule, it is in, you can modify to avoid obscurity. Then mischief rule, suppress mischief, ad- advanced remedy. Then let us see what is mischief rule. Okay, this rule comes from Hayden case 1584. It is the oldest rule that focuses on the purpose of the law. Courts ask, what is the problem with this law to fix? Then they interpret the law in a way to solve that problems. So here, common law. What is the old law before this act was passed? Then mischief. What is the problem of gap did the old law fail to fix? This is a mischief rule. Then law commission reports. So there are there are 68th report 1974 suggests that court should focus on purpose of the law, not just its exact words. Judges should look at what the law was meant to do and social problems it was trying to solve. And 183 reports in 2002 suggest that India should write down clear rules how to read and understand the law. So it also recommended updating the General Clause Act to match how courts work today. Why it matters? So these reports are outside source that courts can refer to. They help judges understand what a law was trying to achieve and fill the gaps where the law is silent. Okay, then penal and taxation statutes. Okay, so penal status, it is both strictly constructed. Okay, penal favors accused, no implication or analogy either, whereas uh, like comparison, taxation statutes both strictly construed. So taxation requires expressive words, no implication or analogy in either. So let us see penal status. So it is related to the punishment. So which read strictly, if there is any doubt, the accused get the benefit. So it cannot be stretched to cover the cases not clearly mentioned. So you can refer R.V. Harris 1836. Wound, so did not include biting. Then taxation statutes, okay, which is related to the tax. So read strictly, you can only be taxed if the law clearly says so. So you can say this K Brandy Syndicate versus IRC 1921. Then CIT versus Sudra Devi 1957. Supreme Court confirmed the strict rule about the taxation statutes. Okay, this is the thing. Then let us go to the next slide. See, beneficial construction. So the laws can be benefited. For example, welfare law. So these laws are read broadly to help the people they protect. For example, Workmen Compensation Act, labor law. So courts side with the workers when the meaning is unclear. Okay. Then social justice. Courts choose the meaning that treat the people fairly and protects those who are vulnerable. So when the court gives judgment, when the courts have the statutes, so it's look about the like affected person, welfare of the people, welfare of the labor, welfare of the, or social justice. That is the unit 3 about the beneficial construction. Let us go to the next slide. Harmonious construction. Okay, what is that? The key principle: read all the sections of a law together, not isolation. A specific rule takes priority over general rule. A later rule overrides an earlier one if they truly cannot reconcile. So that means, so before giving a judgment, one has to read all the sections thoroughly, not one section. So it has to be linked with the parent statute or the rule. So there's the thing. First, you have to identify the conflict. That means you have to what is the exactly problem and read together. You should read not only one law, but you have to read all the laws together. Give effect on both. Okay, so court must every part of the law work. No section statute should be treated as useless or ignored. So whatever the law is mentioned in a constitution or in a statutes, one should not ignore. It should be you should not ignore as useless or ignored. So this is the thing. So let us go to the next slide. External aids to interpretation. So a statement of objects and reasons. So here when you are giving interpretation, you have to take the uh, other things. Okay, so explain why law was made, help clarify unclear parts, but cannot change the clear and plain words. Legislative history. So you have to look after older laws, so committees reports, past court decisions, and the same topic. Then parliamentary debates. So why this law is made, what uh, like what is mentioned in the debates, so that you have to refer. Then dictionaries and international convention. So in order to understand the law or statutes, so you have to refer the uh, dictionaries, and you have to go through the international treaties or agreement, so that it helps the Indian law with the global standards. So external aids to interpretation is that first, uh, like the code you have to remember: SLPLDI, statement, legislative, parliamentary debates, dictionaries, and international conventions. So these are the external aids to interpretation. Then let us go to the how internal tools or internal aids to interpret or aids to explain the statutes with the internal what we have. So you have to refer the preamble. Okay, the preamble, like we the people of India, like, so if you read that one, you come to know what is the purpose of this particular statute meaning, first particular law meaning, then proverse, that means create the exception to the main rule, explanation, clarify, and section meaning does not add to new rights, then schedule as a part of act. You have to read main law and sub laws, then heading. So acts like titles of for sessions have limited use for interpretation. So internal aids, what you have to remember: different schedules you should refer, preamble you have to refer, and you have to see the titles, headings, what is the marginal notes, what is the interpretation clause, what is proverse means exception rule, explanation also you have to think. This in order to have the interpretation of the statutes by referring internal aids or internal tools. Let us go to the presumptions in interpretation. So how you have to presumption in interpretation, when you are interpreting, when you are explaining the law, what presumption you have to take. Okay, against retrospective operation, law apply to the future, not to the past. So unless laws clearly says otherwise. So when you are interpreting, you have to presume that the law is meant for the future, not for the past. Unless if the statute says clearly you have to refer the it is meant for the past, then only it can be considered. So Hitendra Vishnu Thakur versus State 1994. Then against redundancy. So presumption, what you have to assume. So every word in a law has a purpose. No word is wasted or meaningless. So whatever the words written in a law, it is not useless. It is not meaningless. Okay. So it has the purpose that is called as against redundancy. Then against outer auster jurisdiction. So courts can hear case unless the law clearly takes away that power. Vague wording is not enough. You cannot uh, give the like yeah, courts can hear a case unless the law clearly takes away that power. So the court has to hear whatever it says, unless if somebody speaks vague words, that that should be avoided in favor of constitutionality. So every law is assumed to be valid. So whatever the law is mentioned in a book, in a constitution, in a statutes, it is valid. Courts will try to read it in a way that keeps constitutional according to the constitutional provisions. That statute should be there. There is a presumption in interpretation. So when you are interpreting, when you are explaining the words, you have to remember these things. Let us go to the effects of repeal. What is the repeal means? It is the removed. Okay. The repeal law stops working from the date it is removed. So rights had before the repeal is protected. Then ongoing court cases continue under the old law. Implied repeal only happen when two laws clearly cannot both apply. So what is effects of repeal? Okay, that means so like when the law is removed, then that law stops working. Okay, so three types of removal: express removal, implied removal, then consequences. So this is the thing. Then see effects of amendments. Sometimes the law is amendmented, the law is changed. Okay, what is the effect of that? Prospective amendment. So takes effect from the date it is passed, and it is default rule. It does not affect the things already happen on rights already end. That means when the law is changed, so when the date is mentioned, from the date whatever the law is there, that is going to be changed according to the new things. But if it is already given some judgment on the previous one, that cannot be changed. Then retrospective amendment. So goes back in the time, applies to past event, must be clearly stated in that it cannot be remove rights people already have uh, without giving fair compensation. Okay, already given the some things. Okay, some judgments which cannot be changed. So that is the effects of amendments. Then judicial interpretation. So how the judicial courts going to be interpreted. So courts assumes a new apply only going forward. It is only apply to the past. Okay. Uh, if the legislature clearly says so. Okay. If laws says that you have to see previous one, then you have to see only previous one. But the like courts assume that new law apply to only going forward. So new laws apply to the only future future judgments or future acts. So example, you can say that Hitendra Vishnu Thakur versus State 1994. Okay, so this is the thing, effects of amendments. Let us go to the parent and subordinate legislation. So legislation. So parent legislation means the act, the bill is passed in the parliament, okay, which is supreme, which cannot be challenged. If the parliament is made one act, you cannot challenge. The subordinate versus subordinate or delegate legislation. So parent legislation means the acts which is passed in the parliament. Subordinate legislation means rules, sub-rules, bylaws made by parent act subject to ultra-wise challenge and judicial review. So when the main rule is made, that is parent legislation, also subordinate rules also made with the delegates or lower rank people. So when it is aligned with the parent legislation or parent or main legislation, that's okay. If the it goes behind the parents legislation, then it's going to be ultra 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 virus, which can be challenged and which can be judicially reviewed. So the key concept what you have to remember, ultra virus. Okay, if the rule goes behind what the parent law allows, it is invalid. Then judicial review. So courts can cancel delegated law that break the rule. For example, lower court made some law or lower authority people below the parliament. If the laws is going against the parent law, then it's going to be that can be cancelled. Okay, so for example, Delhi Laws Act case 1991 set the limits how much law making power can be handed over down. So for example, Kerala Education Bill, that is the thing. Okay, this is about the parent versus subordinate legislation. Then we'll discuss about the substantive versus procedural law. Okay, see, uh, like substantive law, it defines your rights and duties, and procedure law, what it says, it explains how you have to use the rights in the court. Example, in substantive law, IPC, Contract Act, whereas procedural law, CPC and CRPC. So substantive law usually applies to going forward. For the future state statutes, it's apply statutes law, whereas procedural law, the laws can be applied to the past situations. So substantive law implemented strictly or interpreted strictly, okay, whereas procedural law, it can be broadly, it can look after the past judgment also. So key rules from the court, procedure law can apply to the past cases unless they that take away the existing right. You cannot lose a core right unless the law clearly says so. For example, Garikapati Veerayya versus N. Subbaiah Chaudhary 1957. So Supreme Court ruled on when procedural law applies to past cases. This is about the substantive versus procedural law. Then, so what we have discussed? We discussed about there are 5 units we discussed. Okay, statutes, rules, special laws, aids, repeal. Main rules we discussed about the literal, golden, mischief, and key cases we discussed. So this is the thing. What you have to remember. There are 3 rules. Literal, that means use the plain meaning of words. Then golden rule, avoid a silly or unfair result. Then mischief, okay, fix the problem the law was meant to solve. This is about the three rules. What is the aids? There is the external SLPLDI, then internal PTHMIPES, that is preamble, title, headings, marginal notes, meaning clause, proviso, then explanation schedule. So when you are writing the exam, write the definition plus rule, case and example, so that success will be yours. So this is my small effort in order to clear our fourth sem exams. So go through this particular video again and again so that you will clear your exam. Thank you for listening my class. Signing off, your Mohan.